Okay, so I can start the roll call now. Eleanor Uribe,
Present.
John Sovic,
Present.
Dr. Annette Walker,
Present.
Susan Friedman,
Present.
Dr. Nicholas Boyd,
Present.
Kelly Ranasinghe.
Present.
We have a quorum.
Great, thank you. So now we will go back to Roseanne to talk about the healthcare services.
Yes, so AB 2575 is next up on our agenda. The topic again is healthcare services and artificial intelligence. The Policy and Advocacy Committee considered this bill at its April 17th meeting, but it did not recommend a position. Amendments were coming and we did have those amendments after the P&A committee meeting. So we'll be going over the latest version today. This bill sets guardrails for healthcare workers using this bill calls it clinical decision support systems in healthcare settings by doing three things. It prevents developers from avoiding liability by claiming that a healthcare worker's failure to override an output absolves them from liability. It requires that each health provider or person using a clinical decision system provided by their employer receives a written notice explaining how the system works, its limits, and its data. And then finally, it protects healthcare workers from employer retaliation or discrimination based on their override or reliance on the output of a clinical decision system. Current law provides that a defendant who developed, modified, or used AI may not assert or use in defense in an action against them that stating that the harm that AI autonomously caused, they can't assert or use as a defense that the AI autonomously caused harm to the plaintiff. This particular bill does the three things that I just described to provide a little bit more information about the data that the employer has to provide their workers using AI. The health facility needs to provide written notice of various information, including details of the developer and description of the output, intended use, including intended patient population, cautioned out of scope use, including risk and limitation, development details, including the training set, demographic representativeness, and known biases, and notice that a worker providing direct patient care may override the output if in their independent professional judgment and in their scope of practice, the override is necessary to meet the applicable standard of care or comply with the law. And in most cases, this needs to be provided at least 90 days or upon hire for new hires. The bill also provides that workers providing direct patient care should be free to use their professional judgment to make assessments and decisions in their scope of practice, and that an employer must not retaliate or discriminate against a worker providing care based solely on their override or reliance on a clinical decision system. However, it does not affect a worker's duty to meet the applicable standard of care acting within their scope of practice. And this bill establishes that a worker who is subject to retaliation or discrimination by their employer for using or not using an AI system's output has a right to file a complaint with their employer with the Labor Commissioner. In terms of the reasoning behind this bill, the author states that healthcare workers are being forced to utilize AI tools by their employers, and they should not be forced to set aside their own professional judgment to follow the recommendations of these tools, or held liable for errors when exercising their professional judgment to follow or override the model. And so the P&A committee, when it discussed this bill on April 17th, it was a previous version. So like I said, the committee didn't recommend a position. It was noted during that discussion that the anti-retaliation in the language in the bill, while it is meant to protect employees, may have gone too far, shielding employees for any professional accountability and placing it all on the employer. And I will note that since that discussion, the bill has been amended And the bill now states that an employer may not retaliate or discriminate against a worker based solely on their override or reliance on the output of the system. But it states that this does not affect the worker's duty to meet the applicable standard of care, act within their scope of practice, or exercise independent professional judgment. So there has been some language there that I think mitigates that concern at least a little bit. Maybe it's not sufficient. The board can weigh in on that if they would like. But I think with that, I'll open it up for discussion.
Thank you, Roseanne. Is there any comments from the board? Not seeing any comments from the audience in the room. Okay, not seeing any there either. Moderator, do we have any comments from those online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name or pressing *3 if you've called in. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. I return the floor back to you.
Thank you. Is there any board member that has an interest in making a motion on this item? None? Okay.
So do you want to just take no position?
So we'll take a no position. So
Okay.
Thank you.
All right, moving on to AB 2011. The subject is non-quantitative treatment limitations, and the policy and advocacy recommended position is support. So this bill it's seeking to strengthen California's mental health parity law by codifying some federal regulations, and the federal regulations are called the 2024 Federal Mental Health Parity and Addiction Equity Act rules. And so we would codify that into federal law, and it's in response to the Trump administration stating it will not enforce the 2024 rules pending some litigation that's going on surrounding them. Under current law, there are a couple of mental health parity statutes in place. First, in California law, every health care service plan or disability insurance policy that provides hospital, medical, or surgical coverage must also provide coverage for medically necessary treatment of mental health and substance use disorders on the same terms and conditions applied to other medical conditions. And then there's also federal law, which is called the Paul Wellstone and Pete Domenicini Mental Health Parity and Addiction Equity Act of 2008. And this federal law requires health plans that offer mental health or substance use benefits to ensure that the financial requirements, such as copays and deductibles, and treatment limitations, such as visit limits, are no more restrictive than those applied to medical and surgical benefits, and applies to group plans with more than 50 employees. This bill is really technical, so I'm going to talk about some of the reasoning behind it before I talk about the technicalities. So the author notes that we have the federal and the state parity law, but the enforcement of these laws have been inconsistent. So regulators have faced ongoing challenges providing what's called non-quantitative treatment limits. And these are things like prior authorization, medical necessity, network adequacy requirements. There's ongoing challenges with having those non-quantitative treatment limits be equal for mental health care versus care for things like physical illnesses. So that's kind of the root of the problem that this bill is trying to get at. The lack of clarity is why it's been more difficult for patients to obtain mental health services, according to the author. So in 2024, in response to this, the Biden administration issued rules clarifying requirements for plans and insurers to collect data and conduct some analyses to measure the impact of what are called these non-quantitative treatment limits. So that's what this bill is attempting to implement. The Trump administration has said it's not going to enforce the federal regulations while litigations are pending. So this is basically codifying the federal regulations into California law. With a couple of exceptions. When I talk to the author's office, it's not verbatim because there are some areas of the federal rules that are where California's law is stronger than federal law. So they use some judgment there to not put in weak things that would weaken California law. The pending litigation is the ERISA Industry Committee versus the U.S. Department of Health and Human Services. And the plaintiff ERISA Industry Committee is a national advocacy organization that represents large employers that provide health, retirement, and other benefits to the workforce. They allege that the federal regulation oversteps the federal agency's authority and violates the APA, the Fifth Amendment, and the non-delegation doctrine. So a little bit about what the actual text of the bill does and what a non-quantitative treatment limitation is. Non-quantitative treatment limitations are things like medical management standards, like requiring prior authorization, prescription drug formularies, network tiers with preferred providers versus participating providers, any step therapy protocols, or exclusions based on failure to complete treatment. So this particular bill, the language in it would prohibit a health service plan or an insurer from relying on discriminatory factors or evidentiary standards to design and non-qualitative treatment limitation for mental health or substance use disorder benefits. That is discriminatory if the evidence for the standards or the factor are biased or non-objective in a manner that discriminates against mental health or substance benefits compared to medical surgery benefits. In other words, the NQTL, the non-qualitative treatment limitation, cannot discriminate against mental health versus medical surgery benefits. To make sure that these NQTLs are no more restrictive than they are for medical surgical benefits, the healthcare plan must evaluate relevant data and assess the impact on outcomes, including material differences for the NQTLs. And they must provide both benefits that impose NQTLs on mental health. They need to provide and document comparative analysis of the design and application of each NQTL applicable to mental health service containing specified information. So basically they have to report for each, they have to do a comparative analysis for each NQTL to make sure that it's not discriminating against mental health benefits. And then they have to report these comparative analyses annually to the Department of Managed Healthcare and the Department of Insurance, which regulates health plans. And it defines penalties and actions to be taken for noncompliance. So, as I said at the beginning of this, in April, the P&A committee recommended that the board consider supporting this bill.
Are there any comments from the board? Okay,
Should I state a motion?
if you can, yeah.
Okay.
Sorry, that's what I was gonna do.
I'm sorry. Kelly is waving his hand.
Oh, sorry, Kaylee, go ahead.
I would move to support this this bill. Mental health parity is an extremely important dimension of an equalizing factor for people with mental illness and substance abuse. And the Trump administration has taken multiple hostile actions against both people from the mental health community and people with substance abuse, which included defunding SAMHSA by more than 80%. The parity area of the federal law that he's speaking about is absolutely critical for ensuring that things like step therapy, which requires that people with mental illness fail on certain drugs, which may not be appropriate in their case, particularly for those with severe mental illness like schizophrenia, ensuring that life insurance companies, health insurance companies, mental health insurance companies, and life plans don't implement these sorts of regulations. And in fact, if you look down to the very comprehensive memo which Roxanne drafted, the only two companies which are opposing this are the Association of California Life and Health Insurance Companies and the California Association of Health Plans, which is, not surprising in the least because they don't want mental health parity. It's going to make them pay more money. But ultimately, our goal is public protection, and this helps to protect the public. So I would move to support the bill.
Yes, so I'm going to add to that motion. So the motion is to support and to delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
So moved.
Second,
Okay. Any
Dr. Annette Walker, public member.
any comments from the audience? Moderator, are there any comments from those online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name or pressing star 3 if you've called in. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. I return the floor back to you.
Thank you. I think we're ready for a vote.
Kelly Ranasinghe,
Yes.
Dr. Annette Walker,
Yes.
Eleanor Uribe,
Yes.
John Sovic,
Yes.
Susan Friedman,
Yes.
Dr. Nicholas Boyd.
Yes.
Motion carries.
Okay, moving on. Next we have AB 2259 by Assemblymember Ransom. The subject is prisons and mental health, and the P&A recommended position is support if amended. This bill establishes a 3-year pilot program at the California Department of Corrections and Rehabilitation, also known as CDCR, to provide access to mental health therapy at 2 institutions to certain incarcerated persons meeting specific criteria who are not already classified to receive mental health treatment from CDCR. The bill provides its intent language is that rehabilitation is an essential function of CDCR, and that access to mental health therapy should be available to all people incarcerated in CDCR, regardless of security level or sentence length, without requiring a pre-existing mental health diagnosis. The intent of the pilot program is to support continuity of care for justice-involved individuals by connecting them to community-based providers prior to release and supporting their ability to remain under the care of that same provider. So the bill also specifies that access to mental health therapy at these institutions shall be via virtual therapy opportunities, including confidential telehealth and telepsychiatry, or via contracted or licensed or registered mental health providers who can provide counseling in a confidential setting. The therapy must be offered at least twice a month for at least 50 minutes or as determined by the provider, and be delivered using a short-term evidence-based therapeutic model appropriate for pre-release transitioning planning. The bill also specifies that access to these services are for individuals who are currently not already classified by the department as certain higher level mental health designation statuses. The people who are eligible for this program are incarcerated persons within 90 days of their release date, minimum eligible parole date, or earliest possible release date. They are required to be informed of their Medi-Cal benefits and facilitate enrollment support no less than 90 days prior to their release. And the pilot program services can be covered via Medi-Cal or another available funding source. Enrollment in the program cannot result in the incarcerated person being classified as having a serious mental health disorder without a formal recommendation and that person's written permission, and communications between them and their assigned provider are confidential pursuant to HIPAA. So a few notes. The author notes that currently mental health services are only available to people who are incarcerated that have a pre-existing diagnosis or who are placed into high acuity treatment levels. This ensures that all people in our justice system, whether diagnosed or not, will have access to the care they need for the safety of themselves or others. And of course, it is starting as a pilot program, however. A couple of things that came up that I pointed out to the Policy and Advocacy Committee, and the Policy and Advocacy Committee discussed this at its last meeting. So I'm going to go over a couple of those things. first, there should be a clarification to Penal Code 2693A1 and 2 that talks about providing incarcerated persons access to mental health therapy via two types of settings. It talks about virtual therapy settings, and then the second one named is contracted, licensed, or registered mental health providers. That sentence doesn't really make sense. While virtual therapy is a type of setting, it is unclear what type of setting contracted, licensed, or registered mental health providers is. I think the intent might be to imply an in-person setting using contracted employees, but that piece should be clarified because it's not technically correct or clear. And the second concern was raised at the Policy and Advocacy Committee meeting, and that has to do with the requirement for the short-term evidence-based therapeutic model. PC Section 2693B requires that the services provided in the pilot program be delivered using a short-term evidence-based therapeutic model appropriate for pre-release and transition planning. The concern was raised at the committee about the requirement for the therapy to be short-term and evidence-based. The intent language of the bill states that the intent of the program is to support continuity of care by connecting the incarcerated individuals to a community-based providers who they can remain under the care of. There is a concern, and there is a concern that the short-term therapy is typically intended to problem solve and not address long-term patterns or history. Additionally, there is concern about mandating evidence-based therapy because that can be too rigid and limit a therapist's effectiveness and overlook needs of clients with multiple clinical concerns, diverse cultural backgrounds, and complex problems. Thank you, John, for helping me out with that. For these reasons, the Policy and Advocacy Committee recommended that the terms short-term and evidence-based be deleted. So, the Policy and Advocacy Committee took a support if amended position on the bill, and I relayed those two comments shortly after the meeting to the author and sponsor. So that's where we are at right now. So I'll open it up for discussion.
So you're also going to get clarity on whether it was, because I mean, it could be virtual, but also with the contract provider is maybe what they're meaning.
Yeah, we're not, that sentence just doesn't quite make sense with those two options. It needs to be corrected because it's kind of talking about two different things. So it was that, and then also the comment about the short-term and evidence-based, the request for those terms to be removed is the other thing we would ask for. If you did a support if amended.
Yeah, I could agree with that.
Yeah, so I think we can put forth a motion if that's what we want to do, and then open it up to comments if there's a motion.
Do you want me to read it?
Yes, please.
So the motion would be support if.
Oh, I'm so sorry. So we do have Rebecca Dees back. So our new our board member's back.
Yes. Now you can go. Yeah.
Okay.
Okay. So the motion would be support if amended to consider clarifying acceptable settings in PC 2693A1 and 2, and also to remove the terms short-term and evidence-based therapeutic model in PC section 2693B, and then also to delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Okay, I move that, oh gosh, what was, I moved to,
Everything Roseanne said.
okay, yeah, everything that Roseanne said, make a motion.
Is there a second?
Second.
Okay. Other comments from the board? So I do have maybe a question, and it sounds like I'm looking at John because it sounds like maybe you're felt a little bit more strongly about the term evidence-based being in here. Can you elaborate a little bit further what your concern is?
So as a like industry standard for mental health providers, evidence-based therapies is a definition that specifically focuses on a very small bandwidth of therapeutic approaches. So it doesn't give the therapist who's working with the client the ability to use individualized care. So it usually covers things like DBT or CBT or ACT, things that are described within a certain line of parameters, but that doesn't allow a clinician to actually address the needs of the person in the room. So that's why I would like it to then give more scope for the providers.
So I hear that, and as somebody who feels quite strongly about the importance of delivering effective evidence-based psychotherapy to individuals, I would not be in favor of making that change. If you look at the majority of community mental health providers, where the majority of consumers who are not informed about mental health treatment seek care, unfortunately, they don't receive the type of care that we would hopefully want them to receive in the community because providers aren't delivering evidence-based psychotherapies. I think sometimes there could be a misconception and misunderstanding about what that means, perhaps, but and the flexibility and the latitude that's offered within the ranges of those particular models. So I don't have an issue with the term short term because I would agree with you on that. I think it should be longer in terms of the type of care, particularly in transition because it's very high risk moment in time. But I would have a difficult time accepting removing that because I would actually feel the opposite of that, and that absolutely should be maintained to ensure that we have providers that are delivering models that are helpful for individuals based upon their individual needs. Within standard practice.
And I would respectfully respond to that and the idea that when you hand me a set of techniques that, in this case, let's say are CBT, and that is an evidence-based model that my notes then may be needing to reflect back into the process of this system they're trying to set up, because this is a study, then that means my hands are tied to provide other types of services that may not fall under that model. A lot of insurance providers are using this as a way to contain costs. And so I just have a concern, once again, if you come to me with a certain thing and CBT is not the appropriate approach to take with you, but I've been told I have to use evidence-based models, then that does not give me flexibility as the provider.
Yeah, I think it would perhaps a philosophical difference. I'm assuming, but I would say that there would be a responsibility of the provider to look into the variety of different models that do exist out there that have been established by APA, ACA, AMFT. I mean, there's a number of professional organizations and I lean to APA a lot because I think they're probably the most robust in looking at what are some of these well-established models and accepted models that we can utilize from. And there's clearinghouses as well that could be drawn upon that. And so it's not, I think, as narrow perhaps as maybe it might be discussed here, and that there's actually quite a variety of evidence-based models from children all the way to the geriatric population that the clinician, if they're trained, should be able to draw upon, which is what we would hope they would be, is trained well enough, versed enough to be able to draw upon those models and tailoring that to the specific needs of the individual. So I don't know that I would, again, support that.
And the only response I would have is by removing the wording evidence-based, a provider can access all of that. They can. That's all that removing that says. They could use any of those models. And once again, they could use the myriad other models that also exist as well. So by saying we are only going to do evidence-based, I think we're limiting our clinicians to provide the best care possible.
Can I ask a question? Would it be possible to request replacing the term evidence-based with something else, such as professionally established or professionally recognized, or is there an in-between?
I think it's difficult because that's the term, I mean, that is the terminology that we use in the field is evidence-based psychotherapy, evidence-based treatment. That's kind of the, what we would look at, science informed perhaps might be another, if there was a middle ground perhaps there, but I think that doesn't address John's concerns that, so I'm not sure that there would be an alternative.
And if the program was specifically designed to be studying short-term CBT in this system, then I would support that. But what the bill is saying, this program is looking at how to provide care in a way that's more present and in the moment. So they're not looking to establish a model that works like DBT. This is the way we want to work with all people in this program from now on. From what I read in the bill, it's like we want to see if we can get this access in right away to people who may not have it, if we can get better results. So that's the other thing that I'm just kind of looking at here.
So let me bring us back, Dr. Annette Walker, Public Board Member. So the motion on the table includes striking that short-term evidence base. And what I'm hearing in our discussion here is that, Nick, you don't support taking that out, just so that I'm clear on what.
I support taking out the term short term, but I don't support.
I
taking
see.
out
All
evidence-based.
right. But there is a motion on the table that has been seconded to take it out. Okay.
Take out both of those.
So my thought,
I'm sorry, really quick. Kelly had his hand
go
up.
ahead.
No, the only thing I mentioned is that it sounds like we're all agreed that they should receive some therapy. It's just a matter of what kind, right? And to what extent the therapist can utilize different models. But the provision of mental health services is not in doubt.
Yeah.
Sorry,
Yeah,
Eleanor.
no, I was just thinking that, yeah, we're all in agreement that we think it would be helpful. I believe that whoever's going to be doing this work is going to do a lot of research and have strong recommendations. Like these are evidence-based practices that work. So they would probably encourage it, but it could be, I'm open to, I think that can be encouraged, but maybe it could go, I would say either way, whether it's going to be restricted to evidence-based or what the clinician believes. But I mean, I could also, I can also change the motion, amend the motion, if we decide.
Well, we can make a vote and always, whatever you want to do, but I don't want to sway you one way or
Yeah.
another, but I just to consider that.
I just have one thing. It just prompted something in our MFT education law. It does require in practicum that they be trained on evidence-based practices, but it also has promising mental health practices that are evaluated in peer-reviewed literature. So I don't know if that helps, but
It does help. I mean,
Yeah.
that would be kind of Roseanne's question, perhaps another place
Mhm.
to put something like that.
Yeah, I mean, the other thing, I mean, that's kind of a weird sentence anyway. I mean, the other thing is we could just have request that sentence be taken out and the law be silent. That might make it even worse. I mean, but it is kind of, I mean, the therapist is going to practice within their scope of practice, right? So like even having that sentence in there, I kind of think it doesn't make a whole lot of sense to you're basically telling the therapist how to do their job a little bit. So that's another way we might be able to resolve it, but
So I'm open to amending to strike that out.
so
The evidence-based and short-term.
the possibility. So we could either do a, Christy mentioned, which the language about professionally, except she'd have to read it again, including that in there, or we could just strike the whole sentence that says services provided through the pilot program should be delivered using a short-term evidence-based therapeutic model appropriate for pre-release transitioning planning, including but not limited to brief cognitive behavioral therapy or similarly structured interventions focused on development of coping skills, reentry planning, and stabilization. If the plan is to establish therapy for somebody who's, I mean, I think it kind of begs the question, the therapist is going to treat the client appropriate for the client's situation, right?
Yeah, and I would actually go as far to say that you could strike brief, but not limit to brief cognitive therapy out of there and just end it with, that, you know, I mean, that would even be okay because there's much more than just CBT that could be
Mhm.
considered in this broad range.
Yeah, I'm thinking the whole sentence could go
Yeah.
because I mean, and correct me if I'm wrong. I don't think that the therapist needs to be limited by that sentence whatsoever. If they're licensed or under supervision by a licensee, they should know how to do their job based on the client.
That's a possibility, yeah.
Okay. So that's another option on the table.
But it's your motion, so
Gosh. So I guess maybe we would leave it based on professional recommendations or we can just, yeah, okay. So I'm going to modify or amend to say basically, we'll strike that last sentence.
Do you want me to, you want to strike the last sentence, correct?
Yes.
Okay, so let me read it and you can tell
Okay,
me if I'm wrong.
yes.
How about that?
Okay.
Okay, so the new motion would be to support, if amended, with the request to clarify allowable settings in PC 2693A1 and 2. That's the first amendment. And then the second amendment would be to strike the last sentence of section 2693B, the one that starts with services provided through the pilot program. Strike that entire sentence.
Gosh, let me look to where I'm at.
That's the sentence that has the short-term evidence-based, cognitive behavioral, all that instruction in there. And also the rest of the, and to delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Just lost it.
There has to be a second still. You in first right now.
Yes, we'll go.
Okay. So is that?
Yes,
that's-
yes.
Okay, Susan? You got your microphone on.
I removed my second from the first thing that we read and put my second on this particular motion.
Okay. Are there any other comments from the board on this motion? Ellie? No? Okay.
Your hands up.
Your hand. So I just want to make sure. Okay. Are there any comments from audience in the room?
Hi, Shanti Edrin with CAMPT. Wanted to just start by thanking Roseanne for the review of the bill. Yes, CAMPT is co-sponsoring this bill with the Anti-Recidivism Coalition and Mental Health America of California. Just really quickly, like you already covered, this bill is about access, and it would allow access to mental health therapy to all people incarcerated in CDCR, regardless of security level or sentence length, and without requiring pre-existing mental health diagnosis. Appreciate the conversation, appreciate, working around and clarifying the amendment that the board is looking for. So I'm happy to highlight both the request for clarification and the suggested amendment, or the updated suggested amendment to our team, and greatly appreciate the board's support on this bill.
Any other comments?
Bindu Mukamala with the NASW of California. We support this bill as an important step towards better understanding behavioral health access gaps in California's insurance system. Social workers firsthand see how many individuals struggle to find timely, affordable, and networked mental health care, often leading them to seek out-of-network services and pay out of pocket despite insurance coverage. This data collection will help identify barriers such as provider shortages, network inadequacy, and limited access to culturally and linguistically responsive care. Thank you.
Thank you. Seeing no other comments in the room, moderator, do we have any comments online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions, and I do see a raised hand from Cassandra Clare. Cassandra, you should see a prompt to unmute yourself. So Cassandra, I'll send you that notification again. Go ahead and click on it if you see a request to unmute.
Thank you. Cassandra Clayton, LCSW with CDCR. And I'm just wondering if the board can have conversation with the authors of this bill to provide specific or explicit language that the registrants, the therapists who are registered or licensed, that they are in fact licensed in the state of California or registered in the state of California. Just because there's some concerns about, as far as with telehealth, there seems to be conversations about recruiting clinicians from out of state. So if we can have more clarity in language that explicitly states that the therapist would be licensed and or registered in the state of California. Thank you.
And this is the moderator. I don't see any further requests for comments, so I return the floor back to you.
Great, thank you. I think we're ready for a vote. Go ahead, John.
Roseanne?
Yes.
What do you know about the information from that last comment?
As far as I know, CDCR requires currently people to be licensed. I know there is a legislative analyst office, I believe it was them, did some research on therapists, and one of their recommendations was considering to expand the workforce using out-of-state licensees, but that's not a proposal right now. And so that's, I don't think would come into the discussion on this particular bill. If we saw that sort of bill be introduced, we would definitely weigh in and discuss it, but that's not what's being discussed at this time. I believe that CDCR has a policy where they only allow licensees and registrants, but they are considered an exempt setting. All government entities are exempt settings under our law. So technically, if they didn't want to, they didn't have to. That being said, anything that was introduced to change that, we would absolutely want to weigh in on that.
Thank you. Are there any other comments? Kelly, go ahead.
Yeah, even then, Roseanne, even if they're contracted, they would be limited to 30 days of out-of-state practice, right?
Not in an exempt setting, but most exempt settings, especially government entities, requires licensure anyhow at this point.
Yeah.
Okay. I think we're ready for a vote.
Dr. Annette Walker,
Yes.
Kelly Ranasinghe,
Yes.
Eleanor Uribe,
Yes.
Susan Friedman,
Yes.
Dr. Nicholas Boyd,
No.
John Sovic,
Yes.
Rebecca Thies.
Should I participate in this vote, given I came in the middle of discussion? You only, it was in the board materials. You didn't miss any public comment.
Yeah, I'm following.
Yeah,
Okay.
so you.
I vote yes. Thank you.
Thank you.
Okay, great. Thank you.
All right, moving on to AB 2352.
Forgot to say motion carries. My apologies. Thank you.
AB 2352 is, the subject is Medi-Cal providers, nonprofit public benefit corporations, and the Policy and Advocacy Committee recommended a support position on this bill. So the motion on the table would be to support and to delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill. What this bill does is currently the Department of Healthcare Services, or DHCS, administers the state's Medi-Cal program, and it has been denying Medi-Cal provider enrollment to nonprofit public benefit corporation 501c3s based on an interpretation of the law that only individual providers or professional corporations may enroll. Many of these nonprofit community-based organizations provide Medi-Cal beneficiaries with mental health care, and these denials have created barriers for community mental health providers as they are finding that they are unable to enroll or recertifying, leaving them unable to serve this population. So this bill addresses the issue by explicitly stating in law that nonprofit public benefit corporation 501c3s that provide non-specialty mental health services may enroll in Medi-Cal. So in terms of the background, there's a letter in attachment A that outlines this issue about the Medi-Cal enrollment barriers. These providers, despite delivering non-specialty mental health services to Medi-Cal beneficiaries, are experiencing widespread denials when attempting to enroll or re-enroll through the state's PAVE Medi-Cal enrollment system. This is based on DHCS's interpretation that these nonprofits don't qualify. Several Medi-Cal managed care plans now require PAVE enrollment for contract recertification. And so what the result of this has been, qualified organizations are prevented from obtaining Medi-Cal reimbursement for services, threatening continuity of care and exacerbating workforce shortages and undermining the state behavioral health initiatives. They note that nonprofit community benefit organizations are losing reimbursement for services already rendered. They face disruptions and must lay off staff or consider site closures. So for these reasons, the P&A committee recommended a support position on the bill.
Thank you, Roseanne. Does anybody want to make a motion? Kelly's hand. Kelly, do you have any?
I will move to recommend support for this bill and to adopt it. Roseanne, could you say the language again, please?
Also the language again. So support and delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Thank you. So moved.
I second the motion.
Any comments from the board? Not seeing any comments from the audience in the room?
Shanti Ezrin with CAMT. Roseanne, thank you so much for, again, the review on this bill. This is a bill that CAMT supports, and it's an issue that faces our members for many, many years now. So this bill would make that necessary clarification within law so that the interpretation of the Department of Healthcare Services won't be a barrier for these nonprofit organizations that are legally organized to enroll under the Medi-Cal system. So really grateful for the board's consideration and support on this bill.
Bindu Mukamala with the NASW California. We echo CAMP and urge the board to support this bill. Thank you so much.
Seeing no other comments in the room, moderator, any comments online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We'll give you a moment. I see no request for comment. I return the floor back to you.
Thank you. Seeing no other comments from the board, we're ready for a vote. Thank you.
Susan Friedman,
Yes.
John Sovic,
Yes.
Rebecca Thies,
Yes.
Eleanor Uribe,
Yes.
Kelly Ranasinghe,
Yes.
Dr. Annette Walker,
Yes.
Dr. Nicholas Boyd.
Yes.
Motion carries.
All right, our next bill is AB 2511 by Assemblymember Aaron's Behavioral Health Provider, comparable worth study, and the P&A recommended position is support. And so this bill would require the Department of Industrial Relations to conduct a study comparing the compensation and reimbursement of behavioral health providers with that of similarly situated medical surgical providers. So a little background on current law. It establishes the Department of Healthcare Access and Information to serve as the central source of healthcare workforce and educational data in the state. And then also, current law requires healing arts boards under the Department of Consumer Affairs to request certain workforce data from their licensees and registrants at renewal for future workforce planning purposes. So that data requested includes areas of specialty, location of practice, type of practice site, spoken languages, things like that. And all of that data is gathered at license or registration renewal, and then it is provided quarterly to the Department of Healthcare Access and Information so that they can analyze it. So this particular bill would require a study to analyze compensation and reimbursement payments made by health plans and insurers directly to health providers and medical surgical providers. Also payments made by insurers to intermediaries and health systems for behavioral health services, and payments made by intermediaries and health systems to behavioral health providers. It specifies various methodologies for determining which behavioral health roles are comparable to which medical surgical roles. And then the health insurer and health insurers have to report things like reimbursement rates for service procedure codes for behavioral health services, the distribution of reimbursement rates, and then total aggregate payments to behavioral health providers and medical surgical providers. And that has to be submitted to the department or to the legislature by January 1, 2028. And the reasoning behind this, in the intent language of the bill, the author notes that California is facing a severe behavioral health crisis, largely driven by inadequate access to care, in part due to insurers' longstanding undervaluation and underpayment of behavioral health services. This results in lower provider compensation, higher out-of-network use, and payment flows through intermediaries that may contribute to disparities. This is driving behavioral health professionals away from accepting insurance. So the author is pursuing this study to get more data to identify where and why behavioral health professionals are underpaid so that they can address these issues. The Policy and Advocacy Committee recommended that the board take a support position on the bill. So that'll open it up for discussion.
I'll first ask if there's a motion that someone would like to make on this bill.
I'll motion that we support AB 2511.
Okay, maybe Roseanne can help a little bit.
Yes, support and to delegate, sorry, it's wordy. Delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Can I ask a question, Roseanne?
Yes.
Roseanne, it seems from the language this is a one-time study and not to occur every year or every 5 years. is there consideration of looking not just at one period of time, but rather trends over time in order to help better identify some of the issues here?
This particular bill doesn't do that. I think it's just doing this right now. There might be fiscal concerns, or they might want to see how it goes. So it's possible that they could expand it in the future, but they're not doing that right now. That's correct.
Any other comments from the board?
And then is there a second?
Oh, I'm sorry. We need a second. I apologize.
I'll second.
Second. Comments from the board?
I was going to say, maybe we can recommend that as, that they would follow maybe additional research so that it stays with the standard of living.
Any other comments? Okay. Any comments from the audience in the room?
Bindu Mukamla with the NASW California chapter. We are a recent co-sponsor of AB 2511 alongside the National Union of Healthcare Workers, and we respectfully urge the board's support of this bill. Inadequate reimbursement rates and compensation disparities continue to strain the behavioral health workforce, making it more difficult to retain providers and also limiting Californians' access to timely care. In addition to the overview that you provided, Roseanne, I would like to add that when behavioral health services are undervalued, communities face longer wait times, narrower provider networks, and greater barriers to treatment. So AB 2511 takes a data-driven approach by examining how behavioral health providers are compensated and reimbursed compared to similarly situated medical surgical providers, including across payment flows involving intermediaries and health systems. There are also currently ongoing discussions of potentially amending the bill to move implementation from the Department of Industrial Relations and Labor Code to the Department of Healthcare Access and Information and the Health and Safety Code. And so the findings of the study, we hope, will inform future policy solutions to strengthen parity, support the workforce, and improve access to care across California. And we're also happy to take back the board's comments to the author's office. Thank you.
Question for the board before we move on. In terms of that request, do you want to make that your position contingent on them making it ongoing, or do you want it just to be something that we ask? There may be reasons that they're not doing it, such as fiscal, that I don't know. There might be some kind of reasons like that, but we could certainly provide the feedback without it being contingent on the position. Or if you would like to make it contingent on the position, the position contingent on that, you could do that as well.
I'm okay with it not being contingent. It's just a recommendation, so we don't have to keep coming to the board.
Okay.
I agree that it doesn't need to be contingent, but it is something to consider.
Okay, then I will mention that to them as well in my letter.
Thank you. Okay, no other comments in the room. Moderator, do we have any comments online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We'll give you a moment. All right, I see no request for comment. I return the floor back to you.
Thank you. Are there any other comments from the board before we vote? Seeing none, I think we're ready.
Rebecca Thies,
Yes.
John Sovek,
Yes.
Eleanor Uribe,
Yes.
Dr. Nicholas Boyd,
Yes.
Susan Friedman,
Yes.
Dr. Annette Walker,
Yes.
Kelly Ranasinghe.
Yes.
Motion carries.
All right, moving on to AB 2551 by Assemblymember Ellery. The subject again is healthcare coverage, and the P&A recommended position on this bill is support. And this bill is much in very similar line to the one we just discussed, is that it's seeking to gather information on the prevalence of individuals going out of network and paying out of pocket for behavioral health care and the reasons why. We're really trying to they're trying to get to the bottom of why there are these disparities with getting mental health treatment and people not being able to get it through their insurance. So I've already kind of gone through the mental health parity laws that exist nationally and in the state. I've mentioned that DCA Healing Arts Boards biannually collect certain workforce data when its licensees and registrants renew. And so this particular bill requires Healing Arts Boards to request in that survey that they already take for licensees and registrants. It would require them, the boards, to also request information on whether the licensee or registrant is a contracted provider with a health insurer, either individually or through employment, and the types of insurers they provide services for, such as commercial coverage, Medi-Cal, or Medicare. So it's getting one more piece of data for our licensees so that HCI can use it to kind of get a picture of what's going on with that. The bill also requires healthcare service plans and insurers to conduct an annual optional survey of its enrollees to assess certain things. And that would be the number and prevalence of enrollees seeking or accessing behavioral health care from out-of-network providers, the expenditures they pay out of pocket for out-of-network and in-network care after co-payments, co-insurance, and deductibles, and the reasons that they seek out-of-network care, behavioral health care, and pay for them out of pocket, such as lack of access to affordable, timely, or geographically accessible and culturally and linguistically competent care. The survey findings must be reported to the Department of Managed Healthcare and Insurance annually, and it requires those departments to produce an annual report. Excuse me. So not a lot else to say about this bill. The Policy and Advocacy Committee considered it in April and recommended that the board take a support position.
Is there any motion from the board?
Do you want me to read the motion on the table?
Please, thank you.
Motion on the table would be to support and delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Thank you, Roseanne. Dr. Annette Walker, public member. I'll make a motion as stated by Roseanne.
John Sovek, second.
Comments from the board? Seeing none. Any comments from audience members in the room? Not seeing any. Moderator, do we have any comments online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, press *3. We are displaying in the instructions and we'll give you a moment. I see no request for comment. I return the floor back to you.
Okay, any other further comments from the board? Not seeing any. I think we're ready for a vote.
John Sovik,
Yes.
Susan Friedman,
Yes.
Dr. Nicholas Boyd,
Yes.
Dr. Annette Walker,
Yes.
Eleanor Uribe,
Yes.
Rebecca Thies,
Yes.
Kelly Ranasinghe.
Yes.
Motion carries.
Okay. Moving on to SB 934. The author is Senator Wiener, and the subject is sexual orientation or gender identity change efforts, actions for recovery of damages, statute of limitations. And the policy and advocacy recommended position is support. This bill seeks to establish civil remedies for people harmed by sexual orientation or gender identity change efforts. Current existing law prohibits a mental health provider from engaging in sexual orientation change efforts with a patient under 18, and doing so is unprofessional conduct, subject to disciplinary action by the mental health provider's licensing entity. And then I'm also going to tell you two existing laws of about statute of limitations, because that's going to come into play when we talk about what this bill does. So existing law sets a time limit for action for recovering damages suffered as a result of childhood sexual assault at the later of within 22 years of the date the plaintiff attains the age of majority, or within 5 years of the date the plaintiff discovers or reasonably should have discovered that the psychological injury or illness occurring after the age of majority was caused by the sexual assault. So that one will come into play later because of the time frame of the statute of limitations. And then also another current law sets the time limit for action or injury or death against a healthcare provider based on professional negligence to be 3 years after the date of the injury or 1 year after the plaintiff discovers or reasonably should have discovered the injury, whichever occurs first. So that's currently what would apply in these situations, is the 3 years, 1 year. And you'll notice that the other one is a lot higher. So just keep that in mind as we're talking here. So this particular bill, it provides that an action to recover damages as the result of sexual orientation or gender identity change efforts, the time for commencement is the latter of, if the plaintiff was under 18 when the conduct took place, then the statute is within 22 years of them attaining the age of majority. So you'll see it's the same 22-year period as for childhood sexual assault instead of the 3 years. If the plaintiff was 18 years or older when the conduct took place, within 10 years of the date of the last treatment session where the sexual orientation or gender identity change efforts occurred. And then within 5 years, it's the latter of any of these. So within 5 years of the date the plaintiff discovers or reasonably should have discovered the psychological injury or illness occurring after the conduct was caused by the sexual orientation or gender identity change efforts. And the law specifies that when the plaintiff is deemed to, quote, have discovered, unquote, the psychological illness or injury was caused by the sexual orientation or gender identity change efforts, as when they first knew or reasonably should have known that it was caused in a whole or part by these efforts. They do not need to know the full extent of their injury, a specific diagnosis, or that the conduct was wrong or actionable. So it sets some guidance there. And the bill also outlines the damages a plaintiff may recover, including economic damages, i.e. for medical or mental health treatment expenses or lost earnings, non-economic damages, such as for pain and suffering or emotional distress, punitive damage if conduct was willful, fraudulent, or malicious, and also reasonable attorney's costs. The bill applies to the provisions of the bill apply to any action begun on or after January 1, 2027, and it allows damage claims not litigated to finality but past the statute of limitations to be revived. The bill defines a licensed mental health provider to include the board's license and registration and trainee or social work intern types. So that's what the bill does. Let me go into some background information. The author states that the existing statute of limitations for professional negligence does not adequately account for the delayed recognition of psychological injury that is typical of sexual orientation or gender identity change efforts, noting that the trauma of conversion therapy often takes years to fully surface. The author introduced this bill in response to the recent Supreme Court ruling on March 31, 2026. The Supreme Court issued its opinion in Childs versus Salazar, which was a case involving free speech challenge to the state of Colorado's law prohibiting licensed counselors from engaging in conversion therapies with minors. The court's opinion only addressed the law in Colorado. California was not challenged in the lawsuit, and consequently, it remains current and valid law in this state. The court opinion did not change current California licensure requirements and standards of practice. Licensees are required to comply with applicable state laws and regulations governing practice in California, and the board will continue to monitor the proceedings in Childs versus Salazar and may provide additional updates on that case as needed. So this is basically the author's response to that ruling, this bill. The only staff technical comment that I have on this bill was, and I've already provided it to the office, that the bill uses the term when listing who the bill applies to, it uses the term marriage and family therapist registered intern. It should actually be associate marriage and family therapist. We don't use the intern term for associate MFTs anymore. We have reached out to the author's office to request that they make that correction, and they've indicated willingness to do so. So with that, I'll just say that the Policy and Advocacy Committee recommended that the board take a support position on the bill. And I'll just start with the motion, so that if the board wants to go in that direction, the motion would be to support SB 934 and to delegate authority to the board chair with the assistance of the executive officer to modify the board's position in response to any subsequent amendments to the bill.
Is there anybody on the board that would like to make that motion?
John Sobek, I so move.
Susan, second.
Any comments from the board? Okay. You have a comment?
Yeah, so I looked it up a little bit just because I was trying to figure out what it exactly was saying. And I did look a little bit on the child's. So it was basically, from what I understood, they were saying that something is considered conversion therapy, and there was a challenge of whether maybe the professional using their own professional judgment guiding a session, and maybe whether, if that's considered, someone might consider it conversion therapy, or it could be a professional judgment. So for that reason, I feel like, well, maybe it could be, I guess it could be considered on either side. You know, maybe one can say you could talk with them about one way or the other, or in a sense, it's like blocking, you can't say anything. So in that way, it seems somewhat subjective. And I guess their concern with the Supreme Court was that it could be a violation of the First Amendment for the therapist.
I want to clarify what you just said.
Okay.
Chili's did not say that. Chili's sent back the court to the lower court to apply the strict scrutiny standard. So it's in flux right now, and California law is still very well and alive at this moment. So I just wanted to clarify just the point of the Supreme Court. Again, we don't know how that will affect California law, but California law has not changed at this point.
Okay.
Okay, any other comments? Go ahead, Kelly.
You know, I was sort of waiting for another comment to be made, but I guess I'll go. You know, Chili's v. Salazar was an interesting case to read, but I'm going to read a section from the dissent of Justice Jackson. Not only is conversion therapy ineffective, former participants of conversion therapy report that it causes lasting psychological harm. Gay and transgender children who underwent non-aversive conversion therapy say they were taught to feel shame and self-hatred. And survivors of conversion therapy continue to suffer from PTSD, anxiety, and suicidal ideation. As one survivor put it, conversion therapy came close to killing me. So, you know, from my perspective, Colorado can do what they wish, but if you come into California and perform this sort of torture to our population, not only will you be subject to our regulations and law, but I feel that you should be subject to civil liability as well. And for that reason, I support this bill.
Thank you, Kelly. John?
Hi, John Sobek, LMFT here, an openly queer therapist who works and lives in the state of California. The fact that any conversations about conversion therapy are still taking place in 2026 is disturbing and painful on such a deep level for me. We know for a fact it has been studied by major organizations with peer-reviewed studies and provenance behind them to say that this is nothing but a damaging form of therapy. It destroys lives, it destroys personalities, it shuts down people and harms them in ways that can last a lifetime if they even have that lifetime because they haven't committed suicide in response to this type of therapy. I am always proud to stand with, is it Assemblyman Weiner or Senator?
Senator Weiner.
With Senator Weiner, who has been a leader in trying to protect these populations for quite a while. On a personal level, I have a very close friend who is also a therapist who, when they were younger, was subjugated to conversion therapy. They are currently in their 50s, and in conversations that we have, this experience in their early lifetime still affects them on their daily behavior. Even after doing years of therapy to find themselves, they are a strong, beautiful soul in this world. And yet there are moments when the shadows of that work comes back and makes them feel less than, and still makes them continue to think that they may not have a place in this world. So if this is one small step for that person to be able to step up to the professionals who provided this type of service to him, I say we need to support this bill.
Thank you, John. Are there any other comments from the board? Okay. Any comments from the audience?
Hello, Shanti Ezrin with CAMPT. Thank you for everything that was shared on this bill. And CAMPT supports the intent to remove sexual orientation or gender identity change efforts as a therapy utilized. We are working with the author's office on that indefinite look back provision that's in the bill. So as we're still working with the author, we don't have a position on the bill.
Are there any other audience members in the room? Okay, moderator, comments from online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions and will give you a moment. I see no request for comment. I return the floor back to you.
Thank you. Are there any final comments before we vote? I think we're ready.
Roseanne, I do have a question for you. I just realized this in looking back on this. In the section about this bill in number 1 regarding CCP 34012B, blah, blah, blah. It talks, wait, hold on, it's a little bit lower. Okay, it's actually the one that in number 10 that applies to CCP 340. It says includes efforts to direct a patient to particular gender identity by eliminating, discouraging, or promoting any other particular gender identity or gender expression. I wonder if we can encourage the author to look at that language and include, there's a new style of non-supportive gender identity work that's going out there, which is a process of stalling. So that may not be the exact correct technical word, but it's a form of therapy that's saying, oh, well, that's how you feel right now, but let's wait a year, 2 years, 3 years worth of therapy to stop the process. So I think when we're using these definitions in here, that they might want to explore that and add some wording that looks at that technique too. It's got a specific name that is so escaping my brain right now. Anybody have it?
So Okay, so I'm looking at the actual text of the bill, because that's where we would request the,
Right.
so it's on page 28I11 of the packet. or page-
28, I-11, yes.
So, okay, so I'm seeing.
Which line?
I think it's starting with line
32?
32. So it's defining what sexual orientation or gender identity change efforts are.
Mhm.
So it includes all of the following. So I think it's 32 efforts to direct a patient toward a particular gender identity by eliminating, reducing, or discouraging or promoting any particular gender expression. So basically efforts to, including like efforts to stall.
Yes, thank you. I have an assistant here who found that. So the specific thing is called gender explorative therapy, GET, and it sounds so wonderful and delightful, but the actual design and purpose of it is I come in and say, hey, I'm confused about my gender identity. Then we do this program that takes 1 year, 2 years, 3 years to actually over time wear you down and convince you that that's not true. So stalling is what happens in that technique, but if they look at the GET language, that might help them find if we need to drop that one more thing in there.
So, okay, so it's called gender explorative therapy, and it basically puts
Brakes and interferes on the client's ability to say, yes, this is who I am.
hang on, sorry. Okay, and so it's called gender explorative therapy. Exploratory.
John, can I ask a question?
Mhm.
You don't think the word discouraging covers what you're talking about?
So our lovely legal analysts that I've been around for years now have said that sometimes we had to be really specific with our language to make sure that things are covered.
It's a very specific, so we're talking about a very specific genre of an action, John, correct? And it's in all cases, you're saying that gender exploratory therapy should be prohibited because it's got this end goal in mind, right? Of sort of putting off or putting the brakes on the person's discovery of who they are.
Right, and the model is designed to be opposed to people authentically expressing their
Okay.
gender identity.
Perfect. Yes, so that way I can describe it to the author's office correctly.
And once again, it's a subtlety, but it might, once again, close a loophole.
Okay, so and I'm guessing that with the support position it still stands, but to provide this feedback to them in the letter, separate from the position, it's not contingent on it, but we would also like you to consider this.
Correct, yes.
Okay, yes, I can do that.
Thank you, and thank you to all my assistants who helped me on this.
Roseanne, I actually do have one more question. I only noticed this because we happened to look at it. Is clinical social work intern the correct term, or is it trainee to be consistent with all the others?
Clinical social work intern is the correct
is the
thing.
correct term,
Yes,
okay.
so we call the other two types that are in school trainees, but social work is interns, and then MFT intern is actually incorrect. We call them marriage and family associates now.
All right. Thank you.
It's very confusing.
Yeah.
Yeah.
Okay, was that it? We haven't taken a vote yet. No.
But also, I don't know if there's any more discussion on the gender exploratory therapy,
Yeah.
but if you would like to have more discussion, and also we should go back into public comment just on that one point.
So we'll go ahead and open it back up again for further discussion on the gender I'm going to butcher it, explorative therapy, right? Did I get it?
Exploratory.
Exploratory. Thank you. If there's any comments from the board. Okay, not seeing any comments from The audience in the room? Not seeing any. Moderator, any comments online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name. Or if you've called in, pressing *3. We are displaying instructions and we'll give you a moment. I see no request for comment. I return the floor back to you.
Thank you. I believe we're ready for a vote. Is that correct?
John Sovic,
Yes.
Rebecca Thies,
Yes.
Eleanor Uribe,
Abstain.
Dr. Nicholas Boyd,
Yes.
Susan Friedman,
Yes.
Dr. Annette Walker,
Yes.
Kelly Ronasingi.
Yes.
Motion carries.
All right, moving on to SB 993. The author for this is Senator Ochoa Bogue. And then the subject is Board of Behavioral Sciences licensees notices. And the Policy and Advocacy Committee recommendation was no position or neutral. So this bill is going to be a familiar topic. It creates an exception to the existing law requiring board licensees and registrants to disclose their full name and license information in a written notice to the client when working in acute psychiatric hospitals, correctional treatment centers, or other settings serving incarcerated individuals. It allows those facilities to decline providing that information when necessary for staff safety, as long as the clients are given a clear process to obtain the required details for filing a complaint with the board. So a little bit of background on existing law. All board licensees prior to providing psychotherapy need to provide their client with a written notice containing specified language stating that they are a licensee or registrant of the board, and a contact information for the board where a complaint can be filed. And the therapist must document that in their files that the notice was delivered. On starting July 1, 2025, the board ran legislation to require the written notice also contain the licensee or registrant's full name as filed with the board, their license or registration number, type of license, or an expiration date. In terms of what other healing arts boards under DCA are required to do, all healing arts boards under DCA, except for respiratory therapists, veterinarians, and licensees of this particular board, must communicate to the patient their name, license type, and highest academic degree, either in writing at the patient's initial office visit or in a prominent display area visible to patients in their office. However, there's some certain exemption carve-outs. People who provide medical services to an enrollees of healthcare services plans that exclusively contracts with a single medical group in a specific geographic area are exempt. And then also people who work in a facility license under Health and Safety Code 1250 or in a clinical laboratory licensed under Business and Professions Code Section 1265 are exempt. And this is a pretty large category of people that are carved out here. This is anybody who works in general acute care hospitals, psychiatric hospitals, correctional treatment centers, nursing facilities, and hospice facilities. So other healing arts boards have a pretty big carve out on that information. So this bill allows an employer or an agency of a licensee or registrant to make an exception to providing in the written notice their full name, license or registration number, type of license, and expiration dates based on individual safety concerns in an acute psychiatric hospital, a correctional treatment center, or any setting where mental health services are provided to incarcerated individuals under the jurisdiction of a local, state, or federal correctional authority. If the settings exercise this discretion, they must have an established process by which the client may request and obtain sufficient information to file a complaint with the board. And that process must be disclosed to the client as part of the written notice, and a copy of the written notice must be preserved as part of the client's records. The bill also provides that if the discretion is exercised, the licensee or registrant is responsible for ensuring the process to request and obtain the required identifying information to file the complaint with the board is in place. So in terms of background on this, this issue initially came to the board, and it was discussed at the Policy and Advocacy Committee last October in response to SB 1024 becoming law in 2025. It required the name and the license information to be required in the written notice. And at that time, the board started hearing from numerous licensees working with incarcerated populations who expressed safety concerns about the disclosure requirements, stating that disclosing this information in writing may pose significant safety risks to themselves and their families. So the staff brought this information to the Policy and Advocacy Committee, and it was discussed at the October 2025 meeting. And then at the January 2026 meeting, the board directed staff to bring language to the board for consideration as a legislative proposal. And so the board considered this language originally at its meeting last February in February 2026. However, at that time, board members noted transparency concerns, especially in light of the current national climate, and opted not to move forward with sponsoring the legislation. However, at that time, Senator Ochoa Bogue, who previously carried SB 1024, the required notice language, has emphasized that this matter was brought to her as a constituent concern and presents safety implications for therapists working with incarcerated individuals. So she has chosen to proceed with the legislation. So I think that's pretty much everything that I want to say here. At the Policy and Advocacy Committee, in April, the Policy and Advocacy Committee opted to remain neutral or take no position on the bill. So I'll open it up for discussion.
Any comments from the board?
I will. I know we talked about this recently, but being someone who formerly worked in the prison, just knowing what the safety risks are. I guess my suggestion last time was that it sounds like it's here already, that they had a way for people who are incarcerated to be able to make a formal complaint still, regardless of not having all the information, like the name, all those things. Is that correct, Roseanne?
So the bill basically requires them to have something like that in place, is what it's saying, basically, if the information isn't provided.
Yeah. So my concern before and still now is that, I just still feel like we do have vulnerable population in the prison, and we really need, people that are skilled to work with them, provide services. And my concern is that there may not be people who want to work there due to safety concerns for themselves or for their family. So I personally would like to support it, and I don't know if I can make a motion, but, I just would, like to make a motion to support it.
Is there a second? So there's no second.
I'll second it. Susan Friedman.
So you're seconding supporting the bill, Susan? Susan?
He's asking.
You're seconding in support of this, right? Okay. Is there discussion from the board? Comments? I have maybe a kind of a question that, and I haven't read the whole bill, so it may be in there. Is the process that's required an internal process, or in other words, is it an internal process for CDCRC to be notified of a complaint, or does the process require that eventually gets reported to the board? Because those are two very different things.
So it's, let me find the exact language. It says that, they can waive basically the inclusion of the name and the license number if the setting, so if the correctional facility has an established process by which the client may request and obtain sufficient identification and information to file a complaint with the board. In other words, the name and the license number. And that process has to be disclosed in the notice. So in the written notice, in lieu of the name and the license number, they have to say basically, here's how you can get that information, the information needed to file a complaint. And then they have to preserve, the therapist has to preserve that notice that they provided, so that basically there's documentation that they actually provided it, that like if we were to ask, they could say, look, board, we provided it. That's the process. It doesn't say like you have to do X, Y, and Z, probably because I'm imagining the process isn't the same, you know, in terms of filing a complaint even across all correctional facilities, but they have to have a process and basically document it.
And that notice would be separate from the other notice that's required, correct?
It's included.
Or
It's
part of the
included
same
in it.
notice.
Yeah.
Okay.
I think Kelly's got a question or comment.
Kelly?
So I would recommend the board take an opposed position on this bill, and this is why. I don't think there are sufficient protections involved in the bill to allow for protecting consumers in vulnerable places. In this bill, you're talking about, first of all, you're talking about children because it also includes juvenile detention facilities. Second of all, you're also speaking about institutions which are not merely federally, federal correctional institutions. You're talking about those contract agencies like CoreCivic and GEO that are contract federal institutions that some of our therapists work in. There is absolutely no requirement in the bill as to what information is being provided. If, for instance, the Board of Behavioral Sciences contact information is on there, this is how you file a complaint. This is the license number. This is the email. For all we know, this correctional institution could be saying, well, you go ask the sergeant, and then they ask the sergeant, and the sergeant says, well, maybe you'll get 20 minutes on the computer to figure it out for yourself. There's a host of problems in this bill that really concern me, because if you have a therapist that's incompetent or a counselor that's incompetent, God forbid, in one of these vulnerable institutions that is providing services to children, they can do a lot of damage. They can do a lot of damage in one of these contract agencies, which really go completely unregulated. It's very concerning to me that, and I'm not really concerned about the acute psychiatric institutions or even the federal treatment centers. I'm more concerned about these quasi-federal contract agencies and juvenile detention facilities, which are not as well regulated, where you have profoundly vulnerable populations that are very much in need of services, but you're suddenly taking away that ability and that oversight for these consumers to file protections with the board, and for them to go through another step just to find the information necessary to contact the regulatory entity, which is us, which is, we are the regulatory entity. And our job is not to protect licensees. Our job is public protection. It's to protect consumers. And in all matters, the public protection shall be the primary consideration of the board. So that's what's really concerning me. And it's also concerning me that Senator Ochoa simply took our concerns and said, this is a constituent concern. I'm just going forward. I mean, those are the things that really, really concern me about this bill. They're not taking enough time on this to build in the protections for consumers that can be implemented.
I will clarify one thing. So the written notice requirement that has, I am licensed by the Board of Behavioral Sciences. Here's the, I think it has the website and the phone number to file a complaint. That is still required as part of the written notice. It would be the name and the license number, expiration date, type of license that would not be on there. They would still be required to have the Board of Behavioral Sciences. Here's where you file a complaint in terms of the number and the web address.
Point taken. Yes. Thank you, Roseanne.
But I do think to Kelly's point, sorry, John, did I cut you off? I'm sorry. I do think to Kelly's point that I agree, that the incarcerated population in particular is extremely vulnerable. And there's also a number of immigration institutions that are operating in the state that would fall under a similar consideration. And I do worry about that. And I think the other part to that is, even though the law may state this, the onus of responsibility falls on the institution to ultimately follow through. And so I think the layers that are involved versus an inmate who already is going to have barriers to being able to make a report, just given their status, I think would add additional burdens to that process. And so I do have some reservation. I recognize, I want to acknowledge, Eleanor, your point. I think it's valid, and it's a fair concern, and plenty of other people that share that. So I don't want to minimize that concern. And I also do agree with Kelly that we do need to really consider the context of the population and how in which they are operating in the world is already so limited that their opportunities to pursue those types of things are going to be extremely limited. So that's just what I wanted to say. Go ahead, John.
I'm joining in with the two of you. Initially, when this bill came up to us in an earlier version, we were all like, wow, this needs to be addressed. And we had testimony come to us, and we were like, we have some specific and serious questions. And the more that we have taken a deep dive into this, we have found that there are lots of variables that aren't being addressed by the bill. And that I think this is not a clean enough bill to support. It has lots of things in it that are very questionable, especially in kind of the environment we work in right now, where lots of individual rights are being trampled on, especially in incarcerated populations or people who have been collected off of the streets. Another thing that caught my ear when you were reading a little bit of the bill itself is in the requirements for reporting, it says if this setting has an established process. It doesn't say must, or do they? It says if the setting has an established process by which the client may request and obtain this identification.
Let's see.
It's page 28, M8, line 24.
They may exercise discretion if they have a established process. So if they don't have an established process, then the discretion is not there. That's what that means.
Mm-hmm. Well, and that's what we're trying to investigate, how many of these different programs have established processes.
Right.
And once again, if discretion is involved, we don't have that information. And I think that, once again, does not protect the consumers or the client base.
So I guess my concern still is that, even though like say CDCR and some of the other, or like maybe even the state hospitals might have they probably have something, or I'm sure they have something in place, and there's these other ones that don't. I mean, my suggestion is saying that it must have some type of process, and so I'm just if you just totally throw it out, then it kind of leaves the employees, the workers there at risk. But if there's a way of amending it to say, hey, what is if there's a way of requiring, there's a process.
So I don't think an amendment in terms of that is, so we can't explicitly require CDCR or anything to have a process that's out of our jurisdiction. What this is doing is saying you can only you don't have to provide the name and the license number, but you can only do that if you have a established process in place. If you don't have an established process in place, then the name and license number has to be on there. That's the current status quo right now.
Okay.
So we can't write a law that says all CDCR correctional facilities that use our licensees have to have an established process in place. We don't regulate them, we regulate the licensees.
Okay, so to Kelly's point, then if there's these other agencies that don't have anything in place, then they do have to.
They have to provide the under this bill, if they don't have a process in place, then the law remains that the therapist has to provide the name and the license number.
Yeah, so I feel like that basically covers that concern if you don't have a process, then you have to provide it. But if you do have a process, then this would be that we would basically they wouldn't have to disclose the name.
Correct. And it brings the responsibility back on the therapist to make sure that there's a process. So basically it loops their license into it so that they're personally responsible for making sure that process is in place.
And I think I still have a concern. This is John Sobek again. We have pretty clear evidence that people are not getting blankets, water, access to bathrooms, access to basic health care, feminine hygiene products in a lot of situations that are playing out right now. And so to put in place an assumption, as this bill kind of does, that the system is going to say like, cool, you had bad therapy, here's the form, let's go for it, I think is a little naive on our part, which I agree with Kelly is that this isn't a well-crafted bill. And if this is as important to a senator or assembly person, sorry.
Senator
Ochoa Bog, that perhaps it's about, okay, let's look at writing a bill that is more robust and then provide adequate protections for all parties involved. This bill as it's written does not feel it's doing that for me personally.
This is Susan Friedman. I first of all want to remove my second, but secondly, I think what John is describing are immigration, are these places where immigrants are being held now, and do they qualify as the same kind of institution covered in this bill?
No, they are federal and they're exempt. They're federal and they're exempt, and oftentimes they're not regulated by California law at all. So no, they don't. They're not covered. This is not.
Well, wait a second. I have a question there because the bill includes federal correctional institutions, and the federal government has said, proof positive, we are arresting criminals. And if you're treating detainees like criminals and treating an institution like a federal correctional institution, how I think an argument could be made that it does qualify, especially if a California therapist is engaging in practice inside one of those institutions.
It may be argued, and I'm sure many lawyers would argue that, but they are generally exempt. It is an immigration facility, and I will say there's a lot of detention going on and other things, right, that are similar to criminal proceedings. They are usually generally categorized different than a federal criminal or a federal jail or prison.
Yeah, I know that too, and that was the case a couple years ago. But no, there's way too many unanswered questions, particularly as the statute itself says federal correctional institutions.
Right. Well, and it says correctional institution. So there's definitely an argument, I would say, amongst legal scholars or whoever is challenging that. But oftentimes the federal government is not categorizing those immigration detention centers as prisons.
Okay, let me give you a hypothetical. A California therapist.
Kelly, I'm not going to be engaging in a hypothetical. The question was, does this apply to the immigration facilities? And
okay, I'm asking our board counsel a legal question then. Assume a California therapist is working in a contract facility where the federal government is bringing in federal detainees who are both immigrants and charged with a crime. And that federal facility then says, we have a policy that says you don't have to provide this information because you are our therapist. Do they qualify under the statute?
Honestly, there would be way more facts that we would have to know in order to answer that hypothetical. And again, I am not going to be engaging in that hypothetical discussion.
I agree. I agree. And that's the sort of discussion we should be having before we put forward this bill.
Well, yes, I'm not arguing for support or anything like that. I was just simply answering Susan's question.
I have one other question. Kelly mentioned children. Are we talking about juvenile facilities, which are not federal? They are state?
Well, they can be both, right? Like, I mean, federal may hold juveniles too. It just depends on what the nature of the crime is, or, you know, the facility. I don't really know what the federal juvenile facilities are, but I do know that I know they're mostly state, but they're also, in one of my past lives, I worked in juvenile delinquency court, and they did hold juveniles that were pending immigration hearings in facilities that were technically contracted, but they were state facilities, but there was lots of federal and state stuff going on. And so that's why I'm saying it depends.
Okay.
John Sarek, just a real quick thing. If maybe we can redirect our attention to whether we support this bill or not. There are so many variables that are playing out in this. And I personally just do not support us offering a support position for this bill.
Well,
well,
actually, we don't have a second.
We don't have a second anymore.
We don't have a second anymore. So if you would like to gauge if there is a second, if there is not a second, then.
Correct. Yeah. So Susan did withdraw her second. So we don't have a second for this bill at this time, unless there's anybody else on the board that would like to second this bill.
Can we get feedback from the people that are here and online?
Yeah.
We still have to get public comment. It's just that now there is no motion. That's all.
Yeah. So there's no motion currently, but we will welcome comments from the audience in the room. Not seeing any. Oh, sorry. Come on. Sorry about that.
No.
Oh, there it is. Hey, everyone. Carl Miller, social worker, LCSW at California Healthcare Facility in Stockton. The other day, the police pulled me over, right? I was on my phone driving down the highway. I shouldn't have been doing that. When the police officer came up to the car, he cannot access my address because when I go to CDCR and fill out a form to block my license plate, because inmates will get license plate numbers and try to look me up to find out where I live, right? The police can't find out where I live. That inmate that I walk up to the door, they know these rules. They say, what is your name, full name, what's your license number? They write it down. They call people. I can bring colleagues who have had strange deliveries show up at their door, who have been stalked and had to move because inmates found out where they lived. I have a child at home. I have a wife. I don't want anybody knowing that I work with. I will go in, provide excellent licensed social work care. I do not want them knowing where I live because I want to go home. The police can't figure out where I live because the rules are that I have to put my address online for the BBS. You could say, oh, well, put it at a post office box. I don't want anyone showing up at my post office box. It's these are real life issues. And the gentleman online, I'm sorry, I don't know your name, but he said the board has no obligation to protect the licensee. I don't know if everyone here agrees with that, but that's what he said. So, you know, this is real life.
15
I
seconds.
think you all know that. I mean, I know you all know that. And we want, as social workers, we want to do our jobs and do them professionally and safely as well. Thank you for your time.
Hi. Good afternoon, Madam Chair and members of the committee. My name is Evelyn Beauchamp, and I'm a licensed clinical social worker with the state of California. I'm so proud of myself and my constituents for working diligently to assist our clients and proud of the clients working towards stabilizing their mental health. I represent over 800 clinical professionals as the social work occupational chair with AFSCME Local 2620. I've worked at Department State Hospital Coalinga with sexual violent predators and those with chronic mental illness for 7 years until 2023. And I'm currently working with parolees with a history of mental illness at the Division of Adult Parole Operations. My social work occupational chair constituents are concerned about a boundary infringement in providing first last name license number to clients. The culture in the state institutions with incarcerated or mentally ill population has been to solely provide last name. The rationale is to maintain a boundary of professionalism. We support the author's revision language included in 993. Our licenses are posted with our name and license number. This information is visible and accessible in rooms where we provide treatment. Clinicians provide a written notice as well as a verbal explanation, providing the board's contact information prior to initiating psychotherapy. I believe providing written language specifying our contact information, license number, and instructing the patient client how to make complaints in case of impropriety may create an uneasiness or insecurity with the client.
15 seconds.
Before speaking of a treatment plan, the client's strengths or encouraging words, we're instructing the client, those suffering from mental illness and trauma from incarceration, on the processes to take if they're harmed. This action may derail the trajectory of rapport and therapeutic alignment with client and clinician.
2 minutes are up.
For these reasons, I sincerely request that you consider the revisions of 993.
Good afternoon, Chair and Board. My name is Rafa Garcia, and I am a union representative with AFSCME Council 57, and we represent over 5,000 mental health and social service professionals with the state of California. And one of the things that I do want to make clear is that we support SB 993. One of the biggest things is that this is a restoration of safety and privacy protections. I do want to echo what has been said already. And we are also in a time where the state of California is facing massive vacancies in the mental health professions, and partly because there has been an increase in what was being echoed already regarding threats of violence and other things of that nature. This is one of the things that would help with the recruitment and retention, as Board Member Uribe has talked about, ensuring that folks have access to mental health. And I do appreciate the comments that have been made about people needing to receive services. But if people are not even applying to be in the roles, would they have less access to mental health services? I mean, that is one big thing that also needs to be considered. Is it better to not have the service at all? Or is it also an equal balance to ensure that there's a safeties and protections for our membership, which would be covered by the BBS? And we want the bill also does ensure that there's accountability without compromising safety. And we want to make sure that there is a robust mental health workforce in California. And for that, we ask for your support in SB 993. Thank you.
Go ahead, John.
Could you all sit for just a little bit longer? I want to thank you for your testimony, knowing that you have lived experience in this particular population we're talking about right now. And I wanted to ask you specifically, so this law has been in place for almost a year now. What are you noticing playing out systemically? The law as written requiring disclosure of information. It's been in place since July 1st, 2025. What are you seeing playing out?
Well, for one, and thank you for your question. One, a certain level of just kind of confusion and consternation, right? Like, there are inmates that know that this is the law, and they use that as a tool against us, right? Or they can. And I don't want to broad brush everyone, because it's not everyone. It's not everyone, but there are some. And all you need is one. So a kind of consternation, just kind of like, what is going on? Okay, I have to put my address here, but it's blocked over there, but people can access me. And there are people who have had inmates and friends or somebody of the inmates show up at their house, right?
My specific question is though, with the law that passed, implemented on July 1st, 2025, what are you actually seeing playing out systemically in the work that you're currently doing?
Well, that's part of it, right? That
has there been a rise in cases? Has there been any specific actions that have been taken that you have had reported to your organizations? Have you personally experienced a change that happened in this last year?
So an increase in
I'm sorry,
inmates
hold on,
asking
hold on.
those questions.
You have to limit it to your personal experience because you're not speaking on behalf of the CDCR. So I just want to be clear. So
Yeah, and that's all I'm talking about.
and
Yeah.
just, you know what I mean? It's not in general CDCR or all state hospitals because you're not representative of that.
I'll be clear. I'm only speaking of my personal experience at CHCF, right?
So since July 1st, 2025, you've been required to share this information. How are you seeing it play out?
So let me be clear about something. Within the prison system, there are what are called 602s. The inmate wants to report you.
What is a 602?
That's a perfect question. It is the process that the inmate has a problem with you. They've asked me, can you get me a 602 form? I want to report you. Okay, here's your form. And they have a process that they can report me if they want to. And somebody will come and interview me about their 602, right? Like I said, not every inmate knows about this law, but some do. And those who do, they use it.
So if I can ask for your colleagues' information as well too. Once again, law went into effect on July 1st, 2025. Have you personally been experiencing any repercussions from this that will influence our conversation today?
Well, as I mentioned, my name is Evelyn Beauchamp. As I mentioned in my speech, when you indicate to a client with mental illness or that has suffered chronic trauma that you should call this phone number if you're harmed or if you find that I have done something to harm you, clients get suspicious and they wonder what's on the agenda. What are you planning for me? And so when you ask the question, what can I tell you to positively influence you? That's what I get. And as I mentioned, I have 2 minutes, but as I mentioned, clients with mental illness, they don't understand that there's a possibility, but not so much a probability that they may be harmed from a clinician. And it's just scary to know that this may be predicted for their future, or they're not thinking, that this is a protection mechanism in case someone does something unethical.
Thank you so much for that additional information.
I did want to clarify that I'm a union representative with AFSCME, so I am not currently working in the institutions. What I did want to say is that although I don't have a stat, one is too many. We have advocated for things like alarms at other facilities where it took a murder in order for an alarm system to get changed. So one is too many, and I did want to impress that on the board.
We have to go back to public comment online.
Welcome. Thank you. Thank you, guys. Appreciate it. Do we have public comment online, please?
Yes, we do. We have a couple of raised hands, and for those who might be thinking of commenting, just to let us know you want to comment, go ahead and raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. And we will start with Dr. Jasmine Smith. Dr. Smith, you should see a prompt to unmute. All right, Dr. Jasmine Smith, I'm going to send you a prompt to unmute one more time. Go ahead and click on it.
Can you hear me okay?
Yes, we can.
Okay, sorry about the delay. Good afternoon. My name is Dr. Jasmine Smith. I am a doctor of social work, licensed clinical social worker, and I serve as a director of capacity building with the California chapter of the NASW. I understand the concerns that the board members have shared, and I'm very grateful to see social workers there in the building, because since this law has come into effect, my email has specifically been overloaded with requests from social workers for us to advocate for this in regards to their concern for their safety and well-being. Many of our social workers work in high-risk environments, and they express increased exposure to harassment, intimidation, retaliation due to the populations that they serve. And we do agree with the board that we want to protect those consumers, and we understand that need. And at the same time, it is our role as an association of social workers with over 9,000 members to also ensure their safety, given the increase of violence that social workers and behavioral health providers have experienced, including the death of our providers as well. And so we want to ensure that we are maintaining a stable and effective behavioral health workforce that allows the practitioners, to continue providing critical service to vulnerable populations, including justice-involved populations, while also supporting their safety and their needs as well.
All right, and next we have Vanessa. Vanessa, you should see a prompt to unmute. Go ahead and click on that.
Hello, Vanessa Cervantes, licensed clinical social worker at California Department of Corrections, Centinela State Prison. I just wanted to comment about things that I've seen, changes I've seen since July 1st. It's a lot of the just boundary pushing with patients, because I go over the notice and they know my first name, and then just like calling me by my first name when not even my colleagues or private clients call me by my first name. And it just, I feel like it really like blurs the lines, and some patients get upset about just having to redirect and ask to be called, Miss Cervantes, just out of like respect, and just to keep those boundaries firm. But it just makes me a little nervous to think that it could open it up for patients to like look me up outside because they have my full name, and because they do get upset. Of course, nothing has ever happened, thankfully, but that just it's just a concern. So I'd just like to ask the board to just consider SB 993. Thank you.
And next we have Cassandra Clayton. Cassandra, you should see a prompt to unmute.
Thank you. As a licensed clinical social worker in CDCR, I was previously with the in-prison sex offender treatment program, and we provided the notice to consumers. I think it started in 2022, 2021, And it was just a matter of explaining this is available to you to report complaints to the BBS. However, we do also have the lowest level of a grievance, which would be the 602. So it was just really educating the participant about the BBS. This is a notice, if you need to file a complaint or make a complaint, but we would also encourage them to utilize the lowest level of a grievance within CDCR, which is the 602 process, and also healthcare has a grievance procedure. I agree the language after the comment about juveniles and folks from the immigrant communities who are actually being kind of lumped in with correctional settings. The language can be better. However, the research for this bill references CCHCS. So I think because we are already at the table as far as CDCR clinicians, that we should be included as an exemption for this bill, and just maybe taking a closer look at the language of this bill that would allow exemptions, or just to make it uniform compliance for all correctional settings,
15 seconds,
all populations, that this is required to be provided to patients or folks in custody. Thank you for your time.
All right, and next we have Al Austin. Al, you should see a prompt to unmute.
Hi, good afternoon. My name is Al Austin. I'm a political and legislative director for AFSCME Council 57. As mentioned, we represent over 5,000 mental health professionals, not just in the state, but also in counties and cities, and many of our members work with correctional care or acute hospitals. I wanted to just point out that SB 993, we support and we encourage the board to do so. It actually creates a carve out for a very unique workforce that works with a very, as mentioned, volatile population, but also a vulnerable population. It was mentioned earlier that it's not the board's responsibility to protect the licensees, but I do think it's a moral responsibility to provide a safe work environment for any worker, particularly those who are professionals, and that this particular board licenses. And beyond that, I do think it is may not be the board's particular scope of responsibility, but it is certainly within the scope of responsibility for the state legislature to protect workers. The bill prior to that created this I would just say this environment now was flawed, and with all legislation we work to perfect it and make it better. And this is a mere carve out, like I said, for a very specific population of workers that work in a very specific type of work environment that is very
15 seconds.
Volatile. And so again, we would strongly encourage you all to consider a support position on 993, stand up for protections and dignity for all of professional licensees in the state of California. Thank you.
This is the moderator. I see no further requests for comment. I return the floor back to you.
Thank you, moderator. I do want to mention that the motion initially was support, but there was not a motion for an opposed position, but that is also an option, just to mention that. I'll make a comment if I can. Last time, I appreciate the testimony that was said and shared here. I do appreciate that. And I'll acknowledge that I am a little torn, and I think even initially, because I want to acknowledge and recognize the challenge. Having worked in a correctional setting, I understand your concerns, and I don't want to minimize that in the slightest. I also very much understand, having worked in those types of settings as well, that the policy and procedures don't always flow as intended. And so if you have some individuals that are in precarious positions, they don't always get the same access that they would have if they weren't in those types of restrictive environments. And I think that's where I have a difficult time with this particular legislation. But I just wanted to acknowledge very much your guys' testimony, and I very much appreciate that. Go ahead, Dr. Walker.
Yes, Dr. Annette Walker, public member. Roseanne, I just wanted to go back to the bill itself, SB 993, okay? And we have a subcommittee under BBS, the Policy and Analysis Subcommittee, which meets to review such bills before, analysis before they come to the board for potential to take a stance on it, if you will, which could be no position, which is neutral, or we could support or we can oppose. So this is where we are in this moment. We're considering this, taking into consideration some of the work that was done by the Policy and Analysis Committee. Am I saying, yeah, I got that right. Advocacy, I'm sorry, it's getting a little late. Forgive me. Policy and Advocacy Committee. Thank you, Mr. Sovak. So I guess generally, and Steve, you may want to jump in here too, in this moment when the board chooses to take a neutral or no position, is it because the bill is new and we're monitoring it to see where it might go? Or I'm just wondering, where is this piece, SB 993 in the process?
So the bill is, I believe it's currently in its fiscal committee. It's currently in appropriation. So it's passed its first policy committee. It needs to go to fiscal committee next, and then the floor. And then if it's successful there, toward the end of the month, it will go over to the next house, which would be the assembly. So we're about almost midway through. So that's where it is. It's typically, I don't want to misrepresent my sense from the Policy and Advocacy Committee was exactly this, that there's reasons to support and there's reasons to oppose. So let's just let it play out. So that would be
exactly
what no position is that let the legislature, let it play out, and we will watch or observe.
Exactly. So will it come back to us?
If it changes substantially, then we could bring it back in August.
In August, okay.
But my understanding is that's not very likely, though, given that, right, isn't that what you said, that there wouldn't be much opportunity coming back at this point in August?
At that point, it'll pretty much be through the legislative process. The position would mainly be, it would be like at the tail end of the legislative process. So it's kind of on the line of whether they would take amendments, but it would be basically taking a position for the governor to consider.
But also along the lines of, if you would like to just look at it, you could also direct staff to address some of your concerns with the author's office. It just may not have as much weight if you don't have a support or an opposed position.
That makes
right?
sense.
But they can still clearly have discussions.
Yeah, I kind of stick with that. I'm with Dr. Boyd. And I'm a public member, so, it's like this.
It's a tough one. Yeah.
Yeah, there's a lot you can say.
Public member, it's very hard.
Yeah.
Can I share an experience and part of what, because you had asked, John, you had asked for an experience, and I can share an experience when I was in the prison that was concerning. Is that okay?
Actually, my specific question is, since the new law took place on July 1st, 2025.
But it would be related, because if the person would have had access, then that would have been really, really concerning.
But previous to that law, they would not have had access to all the information.
Yeah, but can I share?
I'm just letting you know
Okay.
what my question actually was.
Yeah, okay. So my experience was, I was a therapist working, and I was working with the hospital, and I had a client who ended up making a threat against a professional. We'll just say it like that. And so I had to put them in the hospital. I had just had my baby, so I was very protective. And then I started thinking, oh my goodness, I know, because they call them kites. they communicate with each other, the people that are incarcerated communicate with each other. So my concern was like, whether it's a kite or whether it's in their art, because sometimes they'll put art and they'll put messages to the outside. So that all started going to my head is like, oh my goodness, I had a little baby, and what about if my information gets out? And so I started thinking, okay, I'm going to put cameras in the house. And this is part of the reason I left. I'm going to put cameras at the house. I'm going to put a fence. So I'm just saying I'm being protective, and then I'm getting a little paranoid. So, and honestly, my interaction with the inmates was, I really enjoyed working there. And but it was just sad that I had to go through that. So I'm just saying, there's people represented that are 5,000 of colleagues, peers that are other professionals. I know I don't want to say, yeah, definitely. I know that's a vulnerable population. And that was part of the reason I really liked being there, because I really liked working with them. But, I know as a board, we've also made stances as far as protecting our own too, as far as that's part of the reason we created the dead name, right, to protect. So I'm just saying, I'm just saying, we can recognize the concern, that there's people out there with families and want to go home. So that's all I'm asking. And so my stance still is to support it. And, even if there was to go back with Roseanne and see if there's any way of working it out, but so versus just deny or not support.
Dr. Annette Walker, public member. So going back to the process, the legislative process. So you said we're about midway through. So we're kind of, lack of better words, monitoring, kind of see where this may go. It will have implications for BBS, one way or another, right?
I mean, if it passes, yeah.
If it passes, yes.
Right?
Yeah. But still, even if it doesn't, we're still.
Well, we still have the same issue. But
Exactly.
Like-
It doesn't just go away. So we'll have implications if it passes. So it's not like we're closing a blind eye to it or anything. At this point, we just may not take a position, or we may. I'm just trying to get the process.
Right.
Okay.
It's going to go over to the assembly side. So the policy committee will be the first to consider it over there.
So Kelly, I don't know if your hand is still raised from before, or if you did have something to say.
No, I don't really have anything to say. I mean, I'm kind of on the same page with Dr. Walker. And, I think it's important to consider the people who are not at the table, the people who are not in front of us. There's 382,000 incarcerated people that are in California, and we haven't heard one voice from them. We've heard a lot from people who have the privilege to come before our committee, people who are educated, people who have unions, people who are making salaries. But we haven't heard anything from a member of the incarcerated population. So it colors our viewpoint. And that's really what I'd like the board to consider, because these are the people that will be affected by this bill. And recognizing the testimony which has come forth, I hope the board can consider that those people are also deserving of protection.
Thank you, Kelly. So at this time, there's not a motion on the table. So we'll recommend that we continue to, what was the recommendation? No position.
It would be
at this
no
point in
position.
time. Yeah. So no position at this time. But so we can move on to the next item, please. Thank you.
Okay, one more bill. SB 1248 by Senator Cabaldon. And the topic is state agencies, automated decision systems. And the Policy and Advocacy Committee did not recommend a position for that bill. The bill establishes safeguards for the use of automated decision systems by state agencies. And so there's a definition of automated decision systems in the law that I'm going to read. It's essentially another word for AI. We've heard several different words to reference AI today, but each bill is a little different. An automated decision system is a computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, such as a score or recommendation, that is used to assist or replace human discretionary decision-making and material impacts natural persons. A high-risk automated decision system is an automated decision system that replaces or assists human discretionary decisions with legal or similarly significant effects, such as decisions that material impact access to or approval for housing or accommodations, education, employment, healthcare, and criminal justice. So this bill is basically setting the stage for potential use in the future of these automated decision systems, high-risk automated decision systems in state government. So the bill requires a state agency using an automated decision system for services to not substitute its outputs for human judgment, not use the system, or they need to use the system to ascertain whether a service application or submission meets minimum requirements. That shall be only one of the factors considered in the decision, and not use this output from the system as the sole basis for an adverse service determination affecting a person, like the denial of a license, expect as expressly authorized in the law. In other words, you can't, if you're denying a license, you can't you have to look at it. You can't let the system make that determination by itself. It has to be reviewed by a person before taking that action. And then also it requires state systems to verify accuracy of system outputs and promote non-discrimination in its use in 3 ways. It needs to ensure the content or recommendations that material affect service levels are reviewed and verified by an employee for accuracy. They need to monitor and periodically evaluate the use of automated decision systems to reduce the risk that outputs contain or perpetuate bias based on protected characteristics such as race, religion, sex, gender identity, age, disability, immigration status. And also requires that personal identifiable information be safeguarded by prohibiting users from entering it into the system. The author's intent in the bill is that California residents and businesses, as we all know, are increasingly using automated systems like AI systems to process things like loan approvals and insurance applications at fast speeds. They note that government services have not kept pace with these advances, and that creates a disconnect between public expectations and the reality of government service capabilities. And it's especially apparent with delays in things like processing professional license applications and other occupational certifications. They note that these automated decision systems have the potential to dramatically reduce processing times for routine government decisions and allow state agencies to redirect, but the deployment of these systems must be done with protections to ensure equity, prevent bias, protect privacy, and preserve meaningful human review. The only thing that I had to actually issue that I wanted to point out, which I don't know that it's necessarily an issue, but I just wanted to make you aware of it, is that if in the future these were to be we were to implement an AI system that would be subject to these guidelines, there is a section that provides that state agencies must safeguard personally identifiable information by prohibiting it from being inputted into an automated decision system. And the bill defines personally identifiable information as things like a residential address or a social security number. The bill does state there is an exception for when necessary for delivery or service administration if there's appropriate safeguards. That language may be too restrictive for the board's purposes, but the exemption might make it acceptable. if we were using this to do something like evaluate a licensee, we would probably need to identify somebody as something like a social security number in order to ensure that we're talking about, for example, the right Joe Smith when we're making a decision, if there's multiples of them. But in any case, DCA and the board always, takes all the steps that required to safeguard personally identified information. It's not like that there's a high standard that is kept in our information security systems. So I just wanted to point that out. The Policy and Advocacy Committee opted not to watch or just not take a position on this bill. In terms of their support and opposition, in terms of the opposition, I looked at the analyses to kind of give you an idea about why there is opposition. The opposition is from several unions. They're concerned about the expansion of these services in government without meaningful engagement from the workers who will be affected. They have concerns that there needs to be a meaningful level of human review and that implementation must occur in partnership with the workforce. So that was kind of what I got out of the main things that were being mentioned in the opposition statements. So just that piece of information for you. And with that, I'll open it up for discussion.
Any comments from the board? Not seeing any comments from members in the room, audience members? None. Moderator, do we have any comments from those online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. I do see a raised hand from Ben Caldwell. Ben, you should see a prompt to unmute.
Thank you. Good afternoon. Ben Caldwell, MFT. I don't think this is particularly impactful in terms of what position you all might choose to take on this bill, but I would just note that the bill's language might accidentally capture license exams, because that is a computer-generated simplified score that serves as the sole basis for the denial of a license. I don't think that that's something that they're meaning to capture in this bill, but depending on what the board chooses to do with it, Roseanne, you may want to work with the author's office to either explicitly get that carved out or just have on the record somewhere that they're not intending to capture license exams with that. Thank you.
Thank you, Ben.
And this is the moderator. I see no further requests for comments, so I return the floor to you.
Great, thank you. Thank you, Roseanne. Okay. Yeah, that's what I was thinking, yeah. So why don't we take a 15-minute break and, oh wait, sorry, go ahead.
No, it has.
Oh, we didn't.
It has to be 15.
Okay, no, but not the 15, but what are we going to do?
No break.
Are we going to just watch it?
Oh, they didn't. There were no motions or positions. Nobody made a motion on it. No.
I'd like a recommendation that we just watch this bill.
With Ben's concern. I think it might not hurt to. Okay. So I'll just provide technical assistance, but no position.
Yeah, and you don't need a motion for that, so that's fine. As long as it's consistent with what the board wants. Okay.
Sounds good to me.
That sound good? So there's no motion, just to reach out with some of what Ben mentioned. Yeah. Okay. Okay. All right. 15 minutes. We'll break. We'll come back at 3:50. So we are going to move on to item number 29, and I will have Roseanne provide us with an overview.
Thanks, Nick. So just a couple of things. The board is pursuing two legislative proposals this year. The first, AB 1598, I've already kind of talked about at the beginning of the meeting. That's the one that restructures and modernizes some of the provisions in the board's licensing process to make the path to licensure more accessible and responsive to real-world challenges faced by applicants. The bill has passed its first Policy Committee, and now it's currently on suspense in the Assembly Appropriations Committee, which is basically what appropriations puts kind of stops every bill in suspense for consideration if it's over a certain fiscal threshold. So that's just kind of the process. It's currently in the Assembly Appropriations, and it will likely move on to the Assembly floor and then head over sometime later this month to the Senate if all goes well. So we're about halfway through on that. SB 1445 is the board's omnibus bill for this year. This bill encompasses a lot of different healing arts boards under DCA. The board originally requested 4 provisions. 2 of them are included right now. There's amendments to clarify what supervisors must assess for appropriateness of utilizing video conference supervision, and then amendments to correct references to incorrect section numbers. The other 2, bullets 2 and 4 in your packet, we're still discussing with committee staff ongoing whether to include the amendments in this bill or to include them in our current 1598 that we're running. So the committee staff is going to make a decision on that, I believe soon, and we'll proceed with pursuing those as well. And the omnibus bill is on second reading in the Senate. So that is the legislative update.
Thank you, Roseanne. Next on the agenda is an update on board rulemaking proposals. So we'll have Christy help us with that.
Thank you. These first 2, we've already talked about today. Fee reductions go into effect July 1st. That's an approved proposal. Continuing education, we considered those comments today. We'll be doing a notice to the public of the second modified text, and hopefully we can get that through the process pretty quickly, because we do have there's a 1-year time limit to get a regulation through from when you first notice it. So the more, anyway, we're trying to we're going to get that going as quickly as we can. The English as a second language proposal is moving. As I've mentioned before, we've had some delays, but it is close to being going to the director of DCA. DCA does have a new director, so there's been a transition. So we're not sure, what the time frame is going to be like on that, but we're keeping an eye on it. And that is a consideration with regulations right now too, with the Business Consumer Services and Housing Agency splitting into 2 agencies on July 1st. There could be changes in timelines for a little while, so we're going to be I'll report on that if that does affect any of our packages. The AMFT RB national exam we talked about today as well. The licensed educational psychologist experience proposal was submitted to DCA for the initial review on April 6th. I did hear back from our regulation attorney, Christy, that there may be some changes to the language that are needed that she noticed in this next set of review. It's always easy to always notice other things. So that's the update.
Thank you so much. So next on the agenda is the suggestions for future agenda items. Are there any future agenda items from?
You have to go to public comment.
Never mind, just kidding. We have to go to public comment. Sorry, are there? No. Are there any comments from the board member? Any comments from the public? Sorry about that. All right. Any comments from the room? None. Moderator, do we have any comments from online?
Thank you, Mr. Chair. If any member of the public would like to comment, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. I return the floor back to you.
Thank you. Sorry about that. Okay, so next on the agenda is the suggestions for future agenda items. Are there any future agenda items, suggestions from board members? I'm not seeing any. Are there any in-house audience participants that would like to suggest future agenda items? I'm not seeing any either. Are there any online audience participants that would like to suggest future agenda items?
Thank you, Mr. Chair. If any member of the public would like to suggest a future agenda item, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. I return the floor back to you.
Thank you. So we'll go on to item 32. Next on the agenda is going to be public comment for items not on the agenda. I will now open for public comments for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during this public comment section, except to decide whether to place the matter on the agenda of a future meeting. Each commenter will have 2 minutes. Do any board members have any comments for items that are not on the agenda? Okay. Are there any comments from our in-house audience participants? None. Moderator, any comments from our online audience participants?
Thank you, Mr. Chair. If any member of the public would like to comment on an item not on the agenda, please raise your hand by clicking on the hand icon next to your name, or if you've called in, pressing *3. I do see we have one raised hand right now from Rick McCarthy. Rick, you should see a prompt to unmute yourself.
Thank you. Good afternoon. My name is Rick McCarthy, LMFT, former BBS oral examiner. Thank you for the opportunity to return and offer a constructive update. First, I want to acknowledge the board's significant work and effort regarding the transition to the MFT national examination. My hope is to strengthen it by eventually integrating a form of structured oral or live competency assessment alongside it. When the oral exams were discontinued in 2003, the decision was driven by cost and administrative burden, not because the exam lacked validity or usefulness. In fact, the oral format uniquely assessed what written tests cannot: how a clinician thinks, responds, and communicates in live clinical situations. We now have an opportunity to address it in a way that is efficient, scalable, and fair. A virtual model, short, structured, rubric-based, with trained evaluators, can preserve rigor while reducing cost and logistical strain. This is not a return to the past. It is an evolution aligned with today's technologically workforce realities. I also want you to know that this effort is gaining momentum beyond this room. I've had encouraging discussions with Senator Tony Strickland's office, and I'm in the process of forming the California Coalition for Clinical Competency, a cross-disciplinary group of licensed professionals committed to supporting the board in strengthening entry standards and safeguarding the public. Our shared goal is simple: ensure that every licensed clinician has demonstrated, not just assumed, the capacity to practice safely and effectively. I welcome the opportunity to collaborate with the board on a pilot or exploratory work group to develop a modern competency component that
15
fits within
seconds.
your current framework. Thank you for your time and your service.
And next we have a comment from Eric Hernandez. Eric, you should see a prompt to unmute.
Hi, thank you. My name is Eric Hernandez. I'm a licensed clinical social worker. On this item, this item was actually brought up earlier in conversation, but I just wanted to bring it to light. On February 23rd, the California Legislative Affairs Office released a report on how to decrease mental health staff vacancies in the CDCR, recommending to the legislator that they allow CDCR to waive the need for mental health clinicians out of state to waive the need for licensure in California. On April 20th, 2026, the federal receiver over the mental health program in CDCR reinforced this recommendation with the Assembly Budget Committee on Public Safety. I'm speaking today as a California licensed clinical social worker, a consumer, and a concerned citizen. I strongly oppose the proposal to waive California licensure requirements for out-of-state clinicians providing telehealth services within CDCR. The statutory mandate of this board is consumer protection, not solving CDCR's administrative staffing shortages. Waiving licensure effectively strips the board of its primary tool for that protection, which is disciplinary oversight. If an out-of-state provider commits an ethical violation or harms incarcerated patient. The board's ability to investigate and hold that provider accountable is severely compromised, creating a dangerous jurisdictional loophole. Patients may be harmed by clinicians unfamiliar with California specific standards of care, legal mandates, and systems of coordination. This includes critical requirements such as duty to protect, involuntary hold criteria, mandated reporting laws, and training in cultural competency and implicit bias. These are not optional, they are essential to safe and effective care, especially for the complex and vulnerable CDCR population. This proposal also
15
has
seconds.
fiscal and workforce implications. It allows out-of-state providers to bypass California licensure fees and other regulatory requirements, while potentially undercutting and desensitizing California clinical social workers, marriage and family therapists, and professional clinical counselors. Just wanted to put this on your radar. Thank you.
And this is a moderator. I see no further requests for comment. I return the floor back to you.
Thank you, moderator. So our last item here is adjournment. I want to thank you all for your participation today. I hope to see you all at our next board meeting that will be held on August 13th and 14th, 2026. Meeting adjourned. Thank you.